to you. And I want a trial brief. I want copies of the pertinent pleadings in areas where you can't get them. Alameda County allows you to take the court file out 3 days before the hearing date. Most counties don't. But what I'm getting at is if the arbitrator has asked you to do something, do it. If he asks you to provide him with copies of the pertinent pleadings, do it. And you as the plaintiff's lawyer are the one that's going to be affected most by this, because remember, you still have a burden of proof in this area. So when he wants a trial brief, give him one. Short, sweet, concise, to the point. He wants the pleadings, send them to him. Respond in a professional manner. I think that you should explore with your adversary the possibility of entering into stipulations to remove issues from the arbitration so that when you come in it can be conducted in an expeditious manner. You have to take into account, obviously, certain factors. Do you want a live body? Your plaintiff, of course you want there. Do you want the police officer? Do you want to put in the police report? Do you want to call the doctor? You want to put in the medical report? You may decide that, and I think in most cases you're going to find that you can reduce this matter to a 2-hour hearing if you follow the rules of Court 1613B cleverly.
And save a lot of money by not having to pay that doctor to come in.
And I think lastly, the thing that I would stress is that while this is an informal matter, it is a legal matter, and I think it is very disconcerting for the clients, the witnesses, to be sitting in a room where the lawyers all walk in and start a hugging and a chucking like the tailor with the fat guy. Treat it like it isn't meant to be, that is to say, a legal proceeding. Don't go on first-name basis. Don't make your client think that you got the arbitrator in the bag because you know him by his first name. Don't make the witness think that this is something that can be treated as, well, we have to be here, but we can get over this because we can go try it in front of a jury and where it really counts. Take it seriously. You treat it right, you'll be rewarded accordingly.
All right, so we've gone through the background, what happens at the beginning, how you go about, what factors you're looking at in terms of trying to decide who you want as your arbitrator, and what you do to get everything done that you need to get done to be ready for the hearing. So we're ready for the hearing, Rich. What do we do? Is this just like a trial, or are you doing something different?
Okay, let's start off the hearing procedure with the hearing brief. We've made reference to this before. I think it's an important aspect, so I want to take some time on it. There is only one authority for the right, the ability to submit a brief to the arbitrator. That's Rule of Court 1614A6. And that simply says that the arbitrator can invite the parties to submit briefs. There is no statutory requirement or rule of court requirement or permission to submit these briefs. It only says the arbitrator can invite the briefs. As has been implied, I invite them as a matter of my usual practice. In my first letter, I say, your hearing date is such and such, please submit briefs under 1614A6. My advice to you is if the arbitrator invites you to submit the brief, do so. Don't ignore the opportunity to submit this to the arbitrator. The real question is, if you're not invited to do so, can you submit a brief on your own? As I mentioned, there's no authority one way or another. My strong feeling on that is yes, you can, and yes, you should. This is just like trial work, especially federal court trial work, in that you know the trial judge before you walk into the courtroom. To my way of thinking, if you can influence the trial judge before you walk into the room, poison the person's mind towards your perspective, you're way ahead of the game. Some people would say you should educate the trial judge beforehand and simply give him familiarity with the issues. I think it goes beyond that. I think it's an advocate's document, and it should be utilized in arbitration proceedings. Now, what should it be?
And let me just say one thing you have to understand. In most cases, all the arbitrator knows about this case at the time you walk in, except for what they have asked you for and you've given to them. All the arbitrator knows about the case is they got a letter from the arbitration administrator giving the name of the case and the names and the addresses of the attorneys. And that's all they know about it. And unless they have asked you for something, quite often they ask for pleadings. I think a lot of them do ask for briefs. But if they don't, if they just ask for the pleadings, most of you know that you can't tell anything from the pleading.
If they're pled right, you can't tell.
And most trial judges, when the case comes into trial and you've got files that are this thick, never go to the bottom of the file to look at the pleadings, because by the time you got to that stage, you're really beyond that issue. So this trial brief issue, I think, is very, very important. And I would strongly recommend that if you have a situation where the arbitrator has not requested a trial brief, that you do prepare one, because it will give the arbitrator that much more of a handle from your perspective of what the case is about. But, Rich, let me ask you this. Do you send it to them ahead of time? And, of course, if you do that, you've got to send it to the other side, or do you walk in and give one to the arbitrator and one to the other opposing counsel same time?
I think this is a prelude to Mr. Gibbs and I disagreeing on something. I firmly believe there's no such thing as a surprise that works in any context in trial law. Surprises backfire. I think if you walk in and you hand it to the arbitrator at the time of the hearing, hoping that you are going to have the pearls of wisdom that the other side will be taken aback by and not prepared to respond to, you're kidding yourself. What's likely going to happen is the arbitrator will say, this is a nice piece of paper, and put it down in the corner of the desk and say, let's start the hearing. I think what you have to do is submit it in advance of the hearing, and you should submit it in sufficient time in advance of the hearing so that the arbitrator will read it. That does not mean then the morning of the hearing. It means several days before. As I said, there's no rule on this, so there's no requirement that you serve the other side with a copy. I would say that it's unethical not to, and that you should serve the other side with a copy of what you give the arbitrator. If that gives the other side the opportunity to respond, so be it. That's what the system's all about.
I still don't like educating my adversary any more than I can help.
And also, there's one other thing I think we ought to talk about in trial briefs, because it is important. The two examples that are in here, this packet of materials that I mentioned before, comes from a program we put on in conjunction with the Bar Association in San Francisco for training sessions for arbitrators. And it was a rather simple motor vehicle collision. So you'll see that the two briefs in this instance, the plaintiff's summary, so-called, and then the defendant's arbitration brief, really simply relate to very simply explaining what the accident is, a sentence or two, how it happened. And then the plaintiff gives you some indication of what the medical bills are and what kind of exhibits are going to be introduced. The defense does talk a little bit more about liability and some of their contentions about why loss of income is inappropriate or something. There's nothing in either of these on the law, because the facts of this case were such that if you have an arbitrator who knows something about personal injury work, there's no reason to give him anything on the law. But I think that's one of the things you have to look at in your case. And the arbitrator in most cases won't want a big explanation of the law, but if you've got some points of law that are either in dispute or uncertain, or that you're concerned the arbitrator may not know, I think it's a mistake not to very briefly touch on those.
Yeah, just let me give you a quick outline of how these briefs would be best written. First, I think you ought to start out with what I call a brief statement of the case. Who wants what? One sentence, two sentences. That's about it. It's what I call the introduction, and I usually head it introduction. And all it says is what this case is about and who's looking for what. I follow that with a factual statement, which again is an outline. I don't mean an outline form. It's a brief recitation of the salient points. You're not arguing the facts. You're not presenting both sides of the story. You're not in any sense trying to be complete. You're simply giving the factual context in which the rest of the case is going to occur. Third thing, you ought to specify the issues, and the wording of your issues, of course, may be determinative on the resolution of them. But they should be a very succinct statement of what you think the arbitrator has to resolve. And that should include not only the factual issues, which are probably the most important, but also any legal issues which you think are going to be important for the arbitrator to focus on prior to the hearing. Lastly, if you think the legal issues justify any kind of briefing, then submit some authorities in your brief, but I say this ought to be very, very short. The arbitrator doesn't want to read a typical trial brief with a full analysis. Get to the heart of what's going on. If there is a general rule of law which is fairly self-evident, such as contracts require offer, acceptance, and consideration, you may want to consider leaving that one out